Okay, let's see. Hold on a second. Mr. Papp, are you able to hear me okay?
Yeah, can you hear me?
I can, yes, thank you.
Or can I ask a couple questions before we get this started?
Yep, let me just call your case real quick and then certainly do that.
Thank you.
We're on the record now in People versus Carl Papp. This is file number 256857. The record should reflect Mr. Papp is appearing today by video from Department of Corrections. If I could have counsel put your appearances on.
Good morning, Your Honor. For the record, Michael on behalf of the people.
Thank you, Your Honor. Richard Shrewsbury on behalf of the Papp.
Okay, thank you. So we're here for a sentencing issue that the court was made aware of by Department of Corrections. But before we get to that, Mr. Papp, you indicated there was something you wanted to say.
Yeah, I was just curious, a couple questions if you could answer for me, because I've been trying to get this answered this year long, but this is actually over a year this has been going on. Truth is that give me a very definitive answer. The other, the district court kind of said something, but I want to make sure, is a preliminary and evidentiary hearing the same thing?
No, I mean, they
I
are
didn't
sort
think-
of. A preliminary hearing is an evidentiary hearing, but there's all kinds of evidentiary type hearings. Preliminary hearing is a type of evidentiary hearing.
What about is it the same thing as a probable cause conference?
You know, now we're getting into the area where I'm not just defining things. I'm giving you advice.
Because the only reason I don't mean to cut you off, John. The only reason I'm asking is because I never had a proper cause, and I've told Richard this from the get-go. I never had a proper cause. I had an evidentiary hearing. I never had a proper cause. They scheduled it before he was my attorney, but I never went to it. Which I kept telling him there's a violation of my due process. But the second thing is, I just got back from the law library before I had this meeting, so I wanted to make sure I don't sound stupid when I'm talking to you. That I'm just curious, and my appellate attorney told me to ask, how is it that they retain a warrant when myself and the so-called victim said this never happened, even testified in front of the district court, I didn't do this, and yet they still went and got a warrant off of a third-party hearsay, which in the Michigan court law states you cannot grant or get a warrant off of hearsay. They have to have proper, like, identifying evidence, in which the victim saying, I did this, which we had an affidavit signed. I don't know if Richard ever turned it into the courts, where Lauren said, I never did this. And then my last thing is, I was never told about a tether until like a month ago from the Department of Corrections. Because I would have never accepted this plea. I would have made sure that they took that off there. Because that hinders my job. Because a person might be like, hey, why you have that? I'm not hiring you. Because as you probably noted in my PSI, I run my own business. And I'm going to continue to do that when I get out. But if a person sees like this thing, they're like, whoa, oh, you're an alcoholic, maybe, because they maybe think it's alcoholic monitor system or something. They're going to assume that I'm a problem and not want to hire me within it, for it hinders my livelihood to support me and my family.
Okay.
Because I was never told this legit, but this whole time, no one ever told me if that's a possibility you could get this. So I'm asking the courts if they would, as the thing I got from the MDOC is to amend it where it is, because that was never brought to me, which I feel that should have been something Richard due diligence, like, hey, you know, by accepting this, this is also a possibility they might not make you, but they can make you. He's never informed me of that in any way, shape, or form to this whole process.
Okay.
This is pretty much accept this plea. This is the best thing you're going to get. If pretty much not, I'm going to spend the rest of my life here. I was like, well, I want to be out one day to see my son.
Okay.
But that was never a part of it. Go ahead.
Just let me know when you're done, because every time I start talking, you start talking again. So I want you to say whatever you want to say, but just let me know once you're done so that I can answer your questions.
Go ahead, Your Honor.
Okay.
All
All right, so the things you raise about the probable cause conference, the warrant, those are both issues that you can raise on appeal. That's not something that's before me to make a decision on today. But those are grounds that your appellate attorney, I'm assuming, you guys will talk about that, and those are things that could be raised on appeal. With regard to the lifetime electronic monitoring, they're two separate issues that we're raising here on that today. You're raising the argument that you weren't aware that that was something that was going to be a consequence of your sentence. That argument also is something for appeal, to tell the Court of Appeals you should vacate my plea because I wasn't properly advised of this consequence. And the Court of Appeals will decide that. So that is also an issue for appeal. Why I set this hearing is by statute, based on your conviction, I have to impose that. And that was something as an oversight or a clerical error that the court failed to do at sentencing. But the fact that I'm required by statute to impose it is a different issue than whether you were properly advised of the consequence of that, and that you might have not entered your plea if you had known about that. That's an appellate issue. Do you see the difference between those two things?
Yes, Your Honor. So my next question is, what happens so if I move out of Michigan, because like Tennessee, where I'm thinking about moving to, doesn't require me to do that? Because this is, from understand, this is just a Michigan law. It's not a countrywide law. It's a Michigan state law. So if I move out of Michigan, technically that does not abide to me, if I'm not mistaken, right?
I do not know. That's something that the parole board would address with you when you're released on parole.
And then my next thing was, because I know this is part of your court, from what it looks like, I'm about to beat my gun charges. It looks very good on that right now. Would I get rescored, not just my time back for that about year, which you already agreed to I would, but would I get rescored because after doing my guidelines, it drops it down like another 2 years on top of that?
Yeah, again, that would be an issue for your appellate attorneys to advise you on. That's, I have no idea what effect it might or might not have. And sitting here today, there's no way for me to know that.
All right.
But that's something that your appellate attorneys would give you legal advice on, the effect of having any conviction vacated, what that would mean for subsequent convictions.
Well, they told me it'd be up to you because it technically, as like you already agreed, it'd go back. If I do beat the gun charges, I'm going back in front of you to get resentenced on this very case to give me my year back. And then on top of that, if I'm just asking for the record, would you allow me to get rescored on top of that then? Because by being because they told me if you take off my 2 gun charges in the 4th degree habitual, it's going to drop my time down. Even if you, again, like how you did max me out to touch my max guidelines, it's going to knock it down another 2 to 2.5 years.
Yeah,
which
so
therefore
that very well may end up back in this court if all of that happens. And if it does, then I'll have briefing from your attorney and from the prosecutor. I'll have a report from the Department of Corrections. And you're right. I mean, ultimately, I might have to make a decision on that. But sitting here today without any of that information and without knowing whether or not that's even going to happen, I can't give you an idea of what I might or might not do a year from now, having all of that information that now I don't have any of that. So I can't tell you what I might or might not do or what the law may or may not allow. So.
Thank you. I just wanted to get some stuff for the record. So when my appellate attorney gets to look at this, because we've both been just dumbfounded by how this whole thing has went down and just how things legit happen, especially when the victim says this never happened and yet I'm forced to take a plea or get 30 years.
Well, I mean, you got her pregnant, so something happened.
But she already did. But even then, we asked, like, well, not in your courtroom, in district court, how Hubbard went about this, because what they didn't tell you, there's been 3 tests, and which is weird, 2 of them came back not mine. One of them all of a sudden did on the very last one that Hubbard brought from Newberry down to wherever the state lab is, which is kind of weird in itself.
All right,
But
well,
it is what
either
it
way,
is.
we're not going to relitigate your case here this
Yeah.
morning. That's something that you can address all of those things on appeal. What we're here for this morning is, again, the error by the court in not imposing lifetime electronic monitoring at the time of sentencing, which the court was required to do. I did review the transcript from the sentencing hearing, and the court did not articulate that for the record. Mr. Rolla, on behalf of the people, do you take any position on this?
Judge, pursuant to the holdings in People versus King, that's Michigan Court of Appeals 297, Michigan 465, 824 Northwest 2nd, 258. It's a 2012 case, and People versus Comer by Michigan Supreme Court 500-278, 901 Northwest 2nd, 553, a 2017 case. They specifically affirm what the Department of Corrections indicated, that for this particular offense, it is mandatory lifetime sentence.
Mr. Trush.
Your Honor, to the extent that Mr. Papp has not already preserved his objection to it by his statements, for his benefit, I would indicate he does object to it. Obviously, he's raised an objection on the basis of not being aware of that as a potential consequence. Additionally, when I communicated with him prior to this hearing, he had raised an objection to me based on it. But effectively, I touched on this when he spoke, but I don't think he articulated it the same way, being a limitation on his ability to basically travel between states. So again, to the extent that he hasn't already preserved those with his statements, I would specifically object on those bases.
Okay, so those objections are all preserved for the record. From my standpoint, based on the conviction in and of itself, the statute does require the court to impose lifetime electronic monitoring. So subject to the objections and appeals, the court will impose that at this time. So we'll have an amended judgment of sentence that will reflect that. Mr. Rolla, is there anything further today?
Not in this case. Thank you, Judge.
Mr. Trush.
No, thank you, Your Honor.
Mr. Papp, we're going to go ahead and disconnect at this time. Thank you.
All right, thank you.
Okay, Mr. Trush, do you have Mr. Jones present?
He is in the Otsego County Jail.
Sir, are you Luther Jones? All right, we have People versus Jones. This is file number 266961. The record should reflect Mr. Jones is present today by video from Otsego County Jail. If I could have counsel put your appearance.
That's the record. I would all the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Jones. Your Honor, we're here today and we do have an amended plea offer for the court, which would contemplate a plea to counts 1 and count 2 with a dismissal of the habitual offender notices. I spoke to Mr. Jones prior to court today. This offer is brand new. I mean, probably 20 minutes ago was made. Mr. Jones has another matter that's presently set, I think, for a district court hearing. I think it's next week. I'll kind of put it to Mr. Jones, but I think based on the new offer, I think we'll likely accept it. But I suspect that we want to get both of them up here to be able to do it. But again, I want to put it to Mr. Jones because it's slightly different than what we had talked about.
Did you want to address him directly?
Oh, sorry.
I don't want to get in between you and your client on that.
So Mr. Jones, did you hear what I indicated about the offer?
Yes, I heard.
Okay. That offer is consistent with what we talked about, but do you want to delay it 30 days to get the other matter up here, or do you want to make a decision on that offer today?
The delay is good.
So I'd ask the court to set it 30 days out so that we can get the other case up here. And frankly, I'd likely would be my advice to him in any event, just because again, it is slightly different. I want to make sure he understands what he's doing before he does anything.
Okay, Mr. Rolla, do you have any objection to that?
I do not, Judge, as the plea offer involves both files. The original offer includes a habitual second. The amended offer allows the withdrawal of the habitual second, but a plea to the case that has not yet been bound up to circuit court.
Okay. So we'll set this for a status conference plea hearing in 30 days. I will indicate for the order that the new case should be assigned to me and set for hearing on the same date as this file. So we'll have both of them heard in June. Mr. Jones, did you have any questions about how we're going to proceed with your case?
No, sir.
Roll anything else in this file?
No, Your Honor, thank you.
Mr. True.
Nothing further on this one.
All right, thank you, Mr. Jones. We're going to disconnect at this time. Mr. Steffi, were you ready with Ms. Hayfowler's matter?
That's good.
If you come forward, please. The court will call People versus Hayfowler. This is file number 266954. The record should reflect Ms. Hayfowler's present here in the courtroom today. If I could have counsel with your witnesses out.
For the record, Your Honor, Mike Rolla, people.
Good morning, Judge John Steffi on behalf of these people.
Mr. Steffi, can you tell me the status of this file?
Thank you, Judge. We're here for a status conference date. We do not have a resolution at this time, so I think we probably need to be asking for a trial date.
Mr. Rolla, how many days of trial do you think this?
Rolla, please, Judge. I'm a little bit surprised by Mr. Steffi's comments since I responded to his request for a plea offer this morning. Perhaps he didn't see a response yet.
Reached out this morning.
Yeah, I did. Your Honor, could we have 2 minutes? maybe?
Certainly, yeah.
Just wanted to ask me for a second.
I was in the fields here. Yeah. Thank you, Judge. Jump in a minute.
Okay. The jail's gonna have Mr. Spatz ready for the polycom. If they want to get him ready, we can.
Yes, sir. I'll get him.
Maybe.
Yes, absolutely. Thank you.
Thanks for passing that.
Certainly. Okay, does that affect how we want to proceed?
Judge, Mr. Rolla indicated an offer that was tendered before is still open and will remain open until the plea cutoff. So we're all good as long as we get a plea cutoff date ahead of time.
Certainly.
Thank you.
Okay. So Mr. Rolla, back to scheduling, is there, how many days of trial do you think that this case would require?
Probably a day and a half, which would be 2 days.
Mr. Steffi?
I would think two days, 3 at max.
And Mr. Rolla, how much time do the people need to be ready for trial?
It's going to be more dependent upon the court docket than our office.
Okay, you're basically ready to go.
Correct, Judge. I mean, I don't believe it's going to be scheduled on the court's docket for 60 to 90 days in any case, and that would be sufficient for prosecution.
Okay, Mr. Steffi.
Judge, I don't have any issues with scheduling for the docket. Thank you.
So I'm gonna set this about 90 days out. For a 2-day jury trial. And the court will set it for a final status conference prior to the trial date on the motion day, prior to the trial date. And that will be the plea cutoff. So Ms. Haythaw, I need you to make sure that you stay in touch with Mr. Steffi. You'll get notice of that final hearing before the trial. That would be the last day to enter into any plea agreement if you wanted to do that. So just make sure you're in touch with your attorney so you're prepared with that decision. Okay. And then the court will also send out notice of the trial dates. Mr. Rolla, are you anticipating any motions?
Not at this time, Judge. No.
Nothing from us at this point either. Thank you.
If there are any, then that final status conference will also be the motion cutoff. So please have any motions filed and notice for hearing no later than that date.
And Judge, just for the record, 2 things for the housekeeping purposes. Previous plea offer that was worker in our office extended back to January 6th of this year. I thought today was the cutoff. I has advised Mr. Step in the hallway since the court setting a final status conference. We will leave the plea offer open until that date. And as a second matter in regards to the motions, there may be a 404B motion, and if so, we'll be filing that pursuant to the court's order.
Okay. So Mr. Steffi, you probably already know this, but when prosecutor files that notice, I consider it the defense obligation to file an objection and notice the objection for hearing. So,
I appreciate the clarity, but yes, that would be my course.
okay, very good. All right. Anything else for your side?
No, Your Honor. Thank you.
Mr. Rolla?
No, Your Honor, thank you.
Ms. Haythaler, do you have any questions about how we're going to proceed?
No, sir.
Okay, thank you.
Thanks, Judge. Have a good day.
All right, sir, are you Jaden Spatz? Oops, hold on one second. You were muted. Can you say that? Are you Jaden Spatz?
Yes, sir.
Okay. All right, we'll go on the record in People versus Spatz. This is file number 266978. The record should reflect Mr. Spatz present today by video from Otsego County Jail. I can have your appearances on.
The record, Your Honor, I call back to people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Spence.
And Mr. File today.
Yes, Your Honor, we do have an offer we intend to take advantage of today. It would contemplate a plea to count 1 and count 2 with a habitual second offender notice, dismissal of the habitual 4th offender notice, the controlled substance second offense notice, as well as count 3.
Mr. Rolla, is that a correct statement of the plea offer?
I believe it is, Judge.
Mr. Spatz, is that the plea agreement that you've discussed with your attorney?
Yes, sir.
And have you had an adequate amount of time to talk to him about that?
Yes.
Do you want to proceed with that plea agreement today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Spatz, are you currently on any kind of probation or parole?
No.
All right. And under this plea agreement, you would be pleading guilty to count 1 as a second habitual offender. Count 1 is possession of a firearm by a prohibited person. As a second habitual offender, the maximum possible penalty you could face for that charge would be up to 7 years. I'm sorry, 7.5 years and a $7,500 fine. Do you understand that?
Yes.
And count 2, which is possession of cocaine as a second habitual offender, the maximum penalty for that would be up to 6 years. Do you understand that?
Yes.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes,
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here on the record today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty to these two charges because you are actually guilty of these charges?
yes,
The information I have indicates that this happened back on August 30th of 2025. Is that the correct date?
no.
Okay. When do you believe that this happened?
February or January 3rd?
2026?
Yeah. Or yes,
Okay. Hold on one second.
And Your Honor, I would indicate that date is consistent with what's on the police report,
The January
the
date.
January 3rd date.
Okay. So, looks like the information is incorrect in the date. So on that date in January, were you present here within Otsego County?
yes,
All right. And at the time that you were here in Otsego County, did you have possession of a firearm?
yes,
And were you prohibited from carrying any firearms because you had a prior felony conviction?
yeah,
Okay. Also at that time, did you have possession of some cocaine?
yes,
Did you know that that's what that was?
yeah,
Did you have any legal right to have any amount of cocaine at that time?
no,
Had you, and you indicated that you had been previously convicted of felony controlled substance offense, is that correct?
yes,
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
Yes, defense is satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
I'm aware of none, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Defense is satisfied.
Mr. Spatz, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept, I'm sorry, both charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. Between now and then, somebody from the probation department will be in touch with you to prepare a pre-sentence report. You'll have an opportunity to go through that with Mr. Trush prior to the sentencing hearing. Mr. Rolla, anything further on this file we need to address?
No, Your Honor, thank you.
Mr. Trush?
Your Honor, there is a bond issue that I would ask court to consider.
Okay.
So the bond is presently set at 10,000 cash or surety. Mr. Spatz has another matter pending, and he can't start that matter until he's able to be released here. They have a hold on him, but they won't begin processing their case until he's there. I'd ask the court to consider modifying the bond. He doesn't have the ability to post $10,000. If the court were to even raise the bond up to a 20,000, 10%, he would be able to post that. he's not going to get released out into the community. He's going to be transported, but the other matter starting is going to allow him to serve the time concurrent. So I'd ask the court to consider that. I've been in contact with his attorney, so if we do need to make arrangements for him to be made available telephonically or via Zoom, we can do that. And we'd waive in-person sentencing to the extent that that was necessary if he is transported somewhere else and that has to happen. But we would prefer to be able to let him get the other matter rolling.
Okay, so he hasn't posted bond in the other matter? He has not posted bond?
He is not.
Okay,
They have a hold on.
okay. But he's not under sentence in this case. Yeah, obviously.
Correct. And as the court knows, if they don't come get him till after once he's sentenced here, it cuts off his
Right.
potential credit anywhere else
Right.
under People versus Gibbons.
Right.
If he posts his bond hearing, it's transported there, we're probably still dealing with some small period of time, but at least we're reducing it.
Mr. Rolo?
Your Honor, it's pleased to be entered in this car, in this case now, the people don't have an objection to that request, how the court chooses to amend bond.
Okay, so Mr. Trush, based on the lack of any objection, I would modify it to the $20,000 10%. So I'll just ask that you prepare a stipulation on that and submit that to the court.
Just to be clear, does the court want a stipulation or just an order?
Sounds like Mr. Rolo is agreeing to it, so.
Either way, Judge, makes no difference. If it's an order, he can submit it to our office by email and get permission. If he does it the other way, we'll do it that way as well. Makes no difference to people.
Okay, Mr. Spatz, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Where is the other matter at? What jurisdiction?
I'm not completely clear. I think it is,
Is it in Michigan?
I think it's Indiana. It's gonna come get him.
All right, so that raises another issue because I don't want to have to bring him back from Indiana.
Well, and that's why
Sentencing.
I said, well, I mean, we would waive in-person sentencing if that becomes necessary to facilitate that.
What are the guidelines in this case?
So on the low end, it's gonna be 10. I think the high end is 28. So it's a situation where we're likely looking at either a long county jail sentence or a shorter MDOC sentence.
All right. I'm changing my mind. I'm not going to allow a modification of the bond, given that it's out of state. If he's transported to Indiana, I have no idea what's going to happen in that case. I don't want him to be released from in that case in custody in Indiana. And then how do we get him back to Michigan? That sounds like I'm not going to put our community in the state of Michigan in the position of having to go find Mr. Spatz and bring him back from Indiana for sentencing. So I'm not comfortable with allowing him to be released unless he can post the bond as it is. So I'm going to deny the request to modify the bond, given that extra information.
Understood.
So we'll proceed with sentencing. I'll get it on the docket as quickly as we can.
Understood.
Okay, Mr. Spatz, that's all for your hearing today. We're going to disconnect this time. You have Mr. Eilber for a couple minutes on this.
I do not see him here.
Nobody's in the hallway?
No, sir.
Okay, we'll go on the record in People versus Greg Albert. This is file number 266962. If I could have counsel put your appearances
On
on.
the record, Your Honor, my phone back to people.
Thank you, Richard Trush, on behalf of Mr. Robbins.
This hearing was set for 9:30. It's now 9:35. Mr. Albert is not present in the courtroom or in the hallway. This was set for a show cause today. Mr. Albert, it looks like, failed to appear back in April, perhaps even March. Has he contacted you at all, Mr. Trush?
He has, I've been in contact with him. The prior hearing, I don't, I think he did appear. I think he logged in via Zoom and was in the waiting room, but the court elected not to admit him.
Mhm.
I think that is a small difference, but it is a difference. When I last spoke to him, we had discussed and his intentions were to docket this matter for a trial. At that time, he had indicated to me that he believed there may be a warrant for him out of Alpena. That was the last communication that I had with him.
When was that, would you say?
The time frame was within the last week.
Okay. All right. So I think if you want, I have no problem docketing this for trial today. I am going to request that the prosecutor prepare a bench warrant. Mr. Albert has continued to fail to appear as ordered by the court. Counsel's aware of this. I just want to make a record that the court orders these individuals to be present here in person. And I don't view signing in the day of your hearing without prior approval of the court by Zoom to be an appearance, because number one, the court's ordered it to be in person, and it's my view that it's not up to the defendant to decide whether they want to appear in person or whether they want to sign in on video. And so I don't view it as an appearance. I view it as a failure to appear as ordered by the court. There's been multiple failures to appear. Mr. Albert is subject to, he's charged with the delivery of methamphetamine as a second or subsequent controlled substance offense as a habitual fourth offender. So we're looking at a life offense, a significant penalty here. So at this point, I think the court's justified in requesting a bench warrant. So Mr. Roll, I will ask that you do that. We will get it on the docket for trial. Mr. Rolla, how many days of trial do you believe this case would take?
Would be 8 witnesses, 7 plus the lab personnel, Judge.
Okay.
So you'll probably a full day, if not a little over 1 day.
I'll set it for 2 days, Mr. Trush. Do you think that would be adequate time?
I'm sure that would be adequate. I would actually have guessed probably 1 day. And then I guess I would suggest to the court a final status conference, and maybe the month before, the same month. Obviously, I don't know that Mr. Albert is in Alpena's jail. I mean, it's certainly possible that he is. If he's in the jail there, that may change his calculus in regards to this case, depending on what he's facing there. So I would just obviously ask for a final status conference. I'm somewhat loath to waste trial dates.
Yep, I would agree. So we'll set it for a 2-day trial at 60 to 90, well, let's say 90 days. The court will set it for a status conference, final status conference prior to the trial date. That'll be the plea and motion cutoff. And if Mr. Albert hasn't been arrested or doesn't appear at that final status conference, we can discuss what to do regarding the trial at that time. What are the other matters we need to address in this file?
Just for housekeeping, the plea offer that was extended back on March 4th, 2026 remained open until the final status conference, Judge. And that was a plea of count 1 without enhancements.
Okay, all right,
Thank you.
and is Mr. Love going to be appearing in person or is he live?
No, he should be appearing in person.
Let's take a short recess.
There are people out here. Yeah,
Okay,
that is Mr. Love out there.
all right. We'll take a short recess and then we'll come back on the record.
Hello?
Sir, are you able to hear me okay?
Yes, sir.
All right, we'll go on the record in People versus Spencer. This is file number 266965. The record should reflect Mr. Spencer appearing today by video by prior approval of the court. If I could have counsel put your appearances on.
The record, Your Honor, my grown Baptist people.
Richard Schuster, yeah, Mr. Spencer. Thank you, Your Honor. We appreciate the accommodation in terms of Zoom. When I spoke to Mr. Spencer on Monday, he had very little voice, so to speak, and was concerned. Well, he told me he would be here in person if he needed to, was concerned that he might be contagious. So we appreciate that accommodation. I did discuss with Mr. Spencer at that time the offer that's been made, what a likely sentence might look like under that offer. He had indicated at that time that he would like the matter docketed for a trial.
All right. Mr. Rolla, how many days of trial do you think?
In this particular case, Judge, we're looking at a one-day trial, I think. It's 3 officers, a witness, and the last person out.
Okay, one day you said,
I believe so, yes, Judge.
Mr. Trush.
I tend to agree. I think ultimately, I haven't discussed it with Mr. Spencer, but at the end of the day, I suspect that we likely will stipulate to the lab. I don't think it's likely we're going to be arguing over what the substances were.
Okay. And is 60 to 90 days enough time for the people to be ready?
I believe so, Judge. Again, dealing with lab personnel, so lab personnel, the court docket, basically control. Thank you.
Mr. Trush.
Whatever time frame works for the court is fine with us.
All right, and then as usual, the court will set this for a final status conference prior to the trial date. That will be the plea and motion cutoff. Mr. Roller, are there any other dates I can address for the people?
No other dates, Your Honor, but I do have something I'd like to place on the record.
Okay, 1 second. Mr. Trush, any other dates?
No, Your Honor.
Okay, so Mr. Spencer, we're going to set your case for trial. The court is going to send you a notice of the date and time of your trial. You'll be required to be here at 8:30 on the morning of trial. There will be one final hearing before your trial date. That's going to be a final status conference. And at that hearing, that is going to be the plea cutoff. So to the extent that you wanted to consider any plea offers, you would have to have a final decision on that final status conference. So it's important that you stay in touch with your attorney, Mr. Trush, so that you're prepared with a final answer as to any plea offers on that date. And again, the court will send you notice of the date and time of both of those hearings. They both will be in person here in the courtroom. Do you have any questions about how we're going to proceed with your case?
No, 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 sir.
Mr. Rolla.
Thank you, Your Honor. 2 things, one of which the plea offer was an alternative. It was to counts 1 and 4, upfront restitution of $410, or if the defendant was unable to make the restitution of $410 upfront at a sentence. It would be counts 1 and 4 as a habitual second. Quite frankly, what's a greater concern is the fact that on April 9, 2026, the defendant called my office and tried to speak to actually Ms. Burton, one of our clerks, and he was advised that we cannot speak to her because he's represented by counsel. And we let defense counsel know about that by an email according to the file. I was in the office because I was out apparently in court at the time, but I want to make sure that both defense counsel is aware of the matter again, and that he clearly advised his client not to be trying to contact our office.
Mr. Trush, have you been able to talk to Mr. Spencer about that issue?
We have, and he knows anything that he needs to address, he can address through me.
Okay. All right, Mr. Spencer, do you have any questions about that?
I'm kind of confused, like on April 19th, was that considering my kid's mother?
April 9th.
I don't know. It really doesn't matter what it was about. The point is that Mr. Rolla cannot speak with you directly because you're represented by an attorney. That would be unethical for him to do that. So any communications that you'd like to have with the prosecutor's office, you should go through your attorney, Mr. Trush, okay?
Okay,
Okay. All right. Thank you. That's all for today. Mr. Spencer, you're free to disconnect at this time.
thank you.
You know, this is at the Lima jail.
Yes, that is Brian Phillips. Mr. Madden is in the Otsego jail, and that's an attorney general case.
We have the jail connect, Mr. Madden.
They're getting up right now, Your Honor.
Okay, great. Mr. Madden is an attorney general case.
Correct.
Okay. And this is Mr. Phillips. Mr. Phillips, are you able to hear me okay?
Yes,
Okay, we'll go on the record in People versus Brian Phillips. This is file number 226358. The record should reflect Mr. Phillips is appearing today by video from Leelanau County Jail. Mr. Trush, how did you want to proceed in this file?
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Phillips. This is a fairly new file for me. I just substituted into it a couple weeks ago. Substituting in for Mr. Gilo. I did get discovery reports from Mr. Gilo. I've been able to go through those, as well as have a couple conversations with Mr. Phillips. There is still some video that we're looking at getting a hold of. I've been in communication with the prosecutor's office. I was notified yesterday that they'll have that to me by the end of the week, which is consistent with their standard practice. So at this time, I would suggest to the court an adjournment of 30 days, I think is likely appropriate. Because again, I need to get my feet under me on the case a little bit more to be able to answer some of Mr. Phillips' questions, and then for us to be able to assess whether or not we want a trial or whether the offer is the right way to go.
All right. The only other thing that I wanted to address, Mr. Phillips, you had filed a motion to have Mr. Gilo replaced as your attorney. Has Mr. Trush's appearance, is that dealt that issue?
yes, that dealt with that issue, Mr. Trush. I didn't know that I already had it replaced. Mr. Gilo wasn't answering my phone calls, wasn't doing anything. The only time I ever spoke to him was in court on a lockout room, so Mr. Trush is already way better than Gilo was, so I'm happy with what happened, I guess.
Okay, so is there any objection to the court just considering that motion withdrawn then based on your appointment as opposed to Mr. Gilo?
I think that's appropriate. I think just sort of the function of Mr. Gilo not doing the felonies anymore rendered that.
Right, okay. Mr. Rolla, do you have any objection to the adjournment?
No, Judge, and I also have no objection to the withdrawal motion.
Okay. Okay, so Mr. Phillips, we're going to set this for another hearing. Mr. Trush will be in touch with you to help you be prepared for that next hearing. Do you have any questions?
About the court case, no, I do not right now.
Okay, all right, thank you. The court's going to disconnect at this time.
Do I have a bond at all for Gaylord? I was thinking about bonding out of Grand Traverse County. I'm in Leelanau being housed for Grand Traverse County. I don't have charges in Leelanau though. I tried to reach out, but they didn't say anything back to me in Traverse City.
Let me check and see what your bond is here. 1 second.
Okay, thank you, sir.
I think that this is technically scheduled as a bench warrant arraignment.
Yeah, so I still have a warrant on him
Oh,
right now, so
Okay,
he doesn't have a bond on that.
okay,
The last bond that I had was from 2022. And it was an 8,000 cash surety bond.
was that ever?
It was posted by Craig's Bail Bonds, but now he's got this warrant.
Right, okay. Okay, so the court is going to order that the warrant be recalled based on the fact that Mr. Phillips is lodged and we know his whereabouts. So we'll recall that bench warrant, so that will no longer be out there. We do need to set a new bond, though, I guess in this case, Mr. Rolla, do the people take any position on that?
No, Your Honor, thank you.
Mr. Trush?
I would suggest to the court, given the circumstances, I think a modest increase is probably appropriate. Would ask that the court take into account that, again, there's also a bond that he's posting in Grand Traverse County.
Okay, so it looks like the bench warrant was issued for Mr. Phillips' failure to appear back in September of 2022. And we received a notice from him this April indicating that he was lodged and wanted to proceed with his case here. So that's a significant period of time, over 3 years. So the court will set bond in this case at $15,000 cash or surety and all other previous terms and conditions of bond. So your bond in this case will be $15,000 cash or surety, Mr. Phillips. So if you're able to post there, then that would be what you would need to post. Otherwise, there would be a hold here in Otsego County for you.
Okay, sir.
All right. Okay, thank you. That's all for today. Mr. Madden, are you able to hear me okay?
Yes, sir.
Go on the record. Just hold on 1 second. Ms. Brenner, are you able to hear me?
Yes, Your Honor. Good morning.
All right, good morning. We'll go on the record now in People versus Madden. This is file number 266973. The record should reflect that Mr. Madden is appearing today by video from Otsego County Jail. If I could have counsel put your appearances on, please.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Madden.
Mr. Trush, can you tell me the status of this file here this morning?
Yes, Your Honor. Similar to the last file, this is a case that was reassigned to me relatively recently. I think I got appointed at 20th or so of April. We've been able to make quite a lot of progress, though, in the 2-week or so period that I've had the case. I've been in communications with Ms. Brenner as well as Mr. Madden. I do believe we have an agreement whereby Mr. Madden will be pleading no contest to 1 and 2. The others would be dismissed. We sent to the court a copy of the police report yesterday. I don't know if the court got it, but I have a copy today. The court did not.
I did not. I was in El Paso yesterday, so I didn't have a chance to get that. All right. And all right, is there any type of sentence agreement along with that?
There is not. I calculated his guideline 0 to 9 months. I think the Attorney General agrees with that assessment, I believe so.
Okay, Ms. Brenner, in terms of the nature of the plea agreement, are those the correct terms?
That's my understanding, Your Honor.
Do the people have any objection to the no contest plea?
No, Your Honor.
And what would be the basis of the no contest, Mr. Trush?
So, Your Honor, there's civil liability. I don't want to get too deep into the weeds on this, but there's still a friend of the court matter that's active. Mr. Madden has indicated to me that he's made some filings there in regards to what the arrearages are. As I explained to Ms. Brenner, I'm hesitant to have him admit things that might jeopardize whatever his filings are there. So that's the purpose.
Okay. All right, Mr. Madden, have you been able to hear everything that we've been saying so far?
Yes, Your Honor.
And the plea agreement, as Mr. Trush stated, is that the plea agreement you've discussed with him?
Yes, Your Honor, under the guidelines of the 0 to 9 months. Yes, sir.
Okay. And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please?
Yes, sir.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir. I do.
Thank you. You can lower your hand. Mr. Madden, are you currently on any kind of probation or parole?
No, sir.
All right, and you understand that by pleading guilty to child support, failing to pay child support, that is a felony that carries with it a maximum possible penalty of up to 4 years and or a $2,000 fine for each count. Do you understand that?
I do.
With that in mind, what is your plea to each of those 2 charges today?
No contest.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
I do.
And do you understand that you're giving up and waiving all of those rights by pleading no contest?
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead no contest?
No.
Has anyone promised you anything other than what we've said here in court today?
Yes, the 0 to 9 months.
Okay, well, that's something that we said in court today, and you have to understand that's what the attorneys believe the guidelines will score out at, but nobody's promising you that that's what it's going to be. You understand
That's the only
that?
reason why I agreed to the plea, sir.
All right, so you don't want to plead no contest if I can't
No, I
guarantee you
do.
that.
I do want to. But I'm just answering your questions honestly, sir.
Well, what you said was you're only entering it because somebody promised you that it would be 0 to 9. And what I'm telling you is no one can promise you that. We have to have a pre-sentence report done, and then the Department of Corrections will tell us what the scoring is. It may be that it's 0 to 9 and the attorneys are right. It may be that they're off on something and it's different than that. So I need to know whether you still want to go forward with the plea knowing that.
I do.
Okay, all right. Aside from that issue, has anyone promised you anything else to get you to plead no contest?
No.
Okay. And is it your own free choice to enter this plea?
Yes.
Ms. Brenner, I'm referring to a police report from the Department of Attorney General. It is reference report number 2234960. Have you reviewed that report?
Yes, Your Honor.
And would you agree that the information contained within that report would support a finding of guilt as to counts 1 and 2?
In general, yes, Your Honor. We did end up adding a few of the counts at the preliminary examination. So I think we would just need to specify the time periods because that isn't specified in the police report. It does specify his failure to pay and that the court had jurisdiction. I would just ask the court to take notice that between the dates of August 1st, 2016 and June 30th of 2017, and then July 1st of 2017 and June 30th of 2018, that's what the report is referring to, that he was ordered to pay child support and he failed to do so during those time periods.
Okay, let me just take a closer look here. So what I have here, the report indicates a time frame from January 1st of 2002 to June 1st of 2022.
Let me see. I'm looking at the original report. Let me see if an updated one was done that I'm not seeing. Judge, is your report signed by Don Christie? Dated June of 2022?
Yeah, yes.
Okay.
Yeah.
All right. We're looking at the same thing.
So having reviewed that, would you agree that it supports at least two of the counts?
Yes, Your Honor.
All right. Mr. Church.
Yes, Your Honor, and I guess I would just say a specific note, I mean, in the detailed breakdown, the last shown payment is 3/3 of 2017. It does, at least what I show, doesn't show any payments after that.
Okay. Yeah, and I would agree with that. Okay, Ms. Brenner, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Church, are you?
No, Your Honor.
Ms. Brenner, are the people satisfied that the court has complied with statute and court rule in taking in this no contest plea?
Yes, Your Honor.
Mr. Church?
Yes, Your Honor.
All right, Mr. Madden, the court finds that your plea is knowing and voluntary. I've marked that report that I identified as Court Exhibit 1. I'm going to admit that to the file as the factual basis. I've reviewed that. I find that it does provide a factual basis to support a finding that you are guilty of 2 counts of failure to pay child support. The court will accept your no contest plea as to each. We'll set this matter for a sentencing hearing. Between now and then, someone from the probation department will meet with you to prepare a pre-sentence report. You'll have a chance to go through that with your attorney, Mr. Trush, prior to the sentencing hearing. The court will notify you of the date and time of that hearing, as well as your attorney. Ms. Brenner, on behalf of the people, is there anything else we need to address today?
No, Your Honor. Thank you.
Mr. Trush?
The only thing I would suggest to the court, I think we're likely to provide the court with some medical information in terms of mitigation here. So the court may want to allot a little extra time for the sentencing hearing. Again, I'm not sure exactly how much it will be, but it might be.
All right, so we'll set
We
aside.
already have the information now. Why make it longer? We already have the information.
We're not waiting longer. We're just gonna give a little extra time for the sentencing hearing so you can tell me everything that you want to tell me about your medical condition.
Oh, I'm sorry, I misunderstood. I thought he meant make it out further. I apologize.
No, we're gonna set it for our next available date.
Thank you, sir.
Okay. All right, thank you. That concludes this hearing. Ms. Brenner, you're free to disconnect, and Mr. Van, we're gonna disconnect.
Thank you, Your Honor.
Mr. Clayune, if you'd like to come forward with your case, Mr. Shaw. The court will call People versus Shaw, file number 256927 and 6928. Record should reflect Mr. Shaw's present here at the courtroom today. If I could have counsel put your appearances on.
Thank you, Judge. For the record, my call, Brian Clean, but here by with Antoine Shaw, the podium of the right purposes of sentencing.
Thank you. Mr. Shaw, today is the date and time set for a sentencing hearing in this case. Have you had an opportunity to go through the pre-sentence report with Mr. Clayune?
Yes, Your Honor.
Mr. Clayune, are there any additions, deletions, or corrections?
No, I found the report to be factually accurate and relevant. I also think the scoring and sentencing guidelines are proper.
Thank you. Mr. Rolla, do the people have any additions that we should get there?
No, Your Honor, thank you.
Any challenges to the scoring?
No, Judge.
Anything on behalf of the people for allocution?
Your Honor, please do the defendant's form. Cards in this order, list number 2, 3, and 7. It's listed as a no prior felonies only because, of course, as the court can tell, the defendant received a 74-11 referral on a controlled substance possession of narcotics less than 45 grams. That was number 3 of 9. The guidelines in this case are 0 to 17 up to 20 years. There's a recommendation to jail with 4 days credit, and that's probably appropriate under the circumstances, as well as the other fines and costs. That's as to found, which is 25, 69. In regards to 29, 69, 27, we have a situation where also we're taking fines and costs, and the court can impose those as well.
Thank you, Mr. Clayton.
Thank you, Your Honor. Mr. Shaw is from the court, 34-year-old, no prior scorable criminal history of any kind. He has appeared to be 10 points as relates to the second file. His offense variables on both cases are also relatively low, landing him in the 0 to 17 range. So this is a very different case than I think that I've heard the court look at today. And I look at it differently for a couple of reasons. One, Mr. Shaw doesn't, even though he has had prior controlled substance convictions that were set aside for the purposes of 7411, I don't see that as a negative. I see that as a positive, that he has done in the past what courts have done or told him to do. It was also 2013, so it's removed a little bit in time, and is a very different person back then. I look at, and I try to assess these, and I talked to Mr. Shaw about his compass scoring, his compass assessment, what that means, and what he's supposed to be working on. And get, full employment. He's now fully employed with 2 jobs. I really told him, we were talking yesterday, we talked again today, if all of our goals, certainly my goals as a father was to be the best example I could for my kids. I told Antoine, I said, are you really doing that? Are you really being the best you can be? I mean, his kids deserve to have more than he had. He didn't have a father. He was raised by his mother. I mean, they deserve to have that. I said, is your current trajectory in life take you in the direction where you think you need to end up? And clearly it's not, But I said, you can do better. I think everybody can do better. And that's why I spent some time talking about his compass scoring, because if you don't know what a compass score is, it kind of can seem like, Chinese arithmetic, I suppose. I said, these are areas of concern. These are areas where if you work on these areas, pro-social activities and substance abuse issues, you can become that person that you want. And it doesn't matter if you come by way of probation telling you what to do, or if you come by organically, just have your own. I guess it doesn't matter sometimes how the sausage is made. We get there, So 4 goals of sentencing you're going to consider protection of society, rehabilitation, deterrent effect for others, and punishment. If we just eliminate for the purpose of this discussion, the idea of punishment, okay, and say, what could this court do to protect society from people like Mr. Shaw who sell drugs? He's drug dealer, he admits it. What can the court do? Well, if the court focuses, like Ms. Davis suggested, that there's a fairly decent likelihood that he'll be successful in probation, and she outlines pretty clearly what she thinks the focus of probation should be. So in that respect, I think she did a nice job assessing the strengths and weaknesses. I think a good sentence would be a probationary sentence focus on primarily the details listed in the compass scoring, helping Mr. Shaw not just get by, but succeed in life. And I'm no way asking the court to issue a good citizenship award here. What I'm saying is that we can stop this from Mr. Shaw. This court, through his sentence and a rehabilitative sentence, can stop the cycle. Mr. Shaw can do better. He wants to do better. He's got a beautiful family. He's got a lot of things. To say that he didn't suffer some loss in this, in his months leading up to this, he buried a lot of family members. I understand that. That's not an excuse. And explain to Antoine, that's not an excuse. It's a reason, but it's not an excuse. You can't use your own personal grief as an excuse for committing crimes. It doesn't work that way. But you can do better. So I think a probationary sentence served where he lives down Allendale, it makes a lot of sense. And he's already demonstrated to a previous judge 13 years ago that he's going to be a success on probation. So I think keeping more of the stick behind him and maybe the carrot in front of him, saying, you know, if you do well, you know, you can ultimately get beyond this and do a better job. I think that's the focus of the sentence as I see it. Now, going back to the question, could the court revert back to the factor I told the court to consider last, and that's punishment. That's the only rational basis I can see to give jail time is to punish. And that is under the Michigan, the guidance of the Michigan legislature, and the Michigan Supreme Court, that is a valid consideration for the court. But I find that courts who look at rehabilitation, I know you do, because I've had sentences, or I know it's important to you. When should that start? And my answer is sooner rather than later. That's my answer. So I don't think delaying the imposition of a probationary sentence makes any sense. I also don't think that delaying Mr. Shaw starting that makes any sense. Certainly, if he violates the terms of probation, if he's back in front of the court, this argument will fall completely flat. But right now, I see there's a promise here. And I think Mr. Shaw is right now in his mind willing to start making positive changes, get the negative influences out of life and focus on the positives. So I'd ask the court to impose a probationary sentence with the conditions outlined in the pre-sentence investigation report and suspend on the issue of upward incarceration.
All right, thank you. Mr. Shaw, was there anything you wanted to say today?
Yes, Your Honor. I know what I was doing was wrong, and I was going through a tough time with financial, about to lose my house. I had 5 kids to raise. It was just a tough time. I made some bad decisions, messing with drugs and consuming them and drinking alcohol. But that's not the person I am. I'm a great worker. I have whole jobs. I've been working since I was 17, on and off. It's just I got caught up at a bad time, God. If I am given a chance to show you and prove that, I can't do that. I will not. I'm not that type of person. I'm not a bad person. I don't go through making these type of decisions. I really am the head of my family. I help take care of all my family, all my brothers, since I have over 10, 15 nieces I take care of. It's just, I made some wrong decisions, some bad decisions. That's not me. As you can see, I don't go around doing stuff like this all the time. It's just I made some bad decisions at the time. And I do apologize to the Gaylor, to the county. I do apologize for the decisions I did make. That wasn't right.
All right, thank you. Mr. Shaw, I did read through the pre-sentence report, so I'm familiar with all the information in the report, including the activity that you were engaged in that brings you before the court today, as well as your past history, your background, and your circumstances and so forth. So I take all of that into consideration, along with what you had to say, what your lawyers have had to say, what your lawyer has had to say, and what Mr. Rolla had to say. I look at all of those things and try to arrive at a sentence that's reasonable, that accounts for your conduct in this case, but also allows for, as your attorney indicated, rehabilitation. I think certainly your past success on probation is an encouraging thing. I agree with Mr. Clayton on that point. I think it indicates that you are able to conform and to follow the rules and to do what you're supposed to do. And so I think because of that, that does give the court an indication to believe that you would be successful on a term of probation in this case. Flip side of that, of course, is you've already been through this. You kind of know what the deal is, and you've been on probation, and yet you continue to reoffend. And even though there was a significant period of time in between that, again, you can view that both ways. You can say that's positive because he wasn't getting into trouble for a long time. You can say it's a negative because despite that, here we are again. After all this time, and you're older and more mature and theoretically going to make better decisions. But you did it in this case. So I think you can look at those things. There's two sides to that coin. Ultimately, I do think that a term of probation is appropriate. I think that you can and would be successful on that based on your past successes. And so the court is going to make probation a part of your sentence. I also think, though, that the court can't ignore the punishment part of this. I think they're does need to be a punishment for you for engaging in this activity, and to act as a deterrent so that people understand generally that if you're going to come to Otsego County and sell dangerous substances to other people, that there is a price to be paid for that. And I know you were going through a tough time and that may have led you to engage in this, but selling it to other people, all those people are going through tough times too, and you're making it possible for them to use drugs. It's not that you're just using it yourself. When you're selling it, you're harming other people by giving them access to something like that, and you're making money off of it, even if that's to support your own habit. You're helping other people be put in harm's way. And so again, I think that deserves a level of punishment. So the court is going to sentence you to probation as to both files, 2 years as to each. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. The court is going to order that you serve 6 months in the Otsego County Jail on each file. Those sentences to be served concurrent to each other at the same time. You do have credit for 4 days served. The court is going to order as to file number 6927. The court is going to order a crime victim assessment of $130, $68 state cost, and a fine of $500. As to file number 6928, the court is going to order restitution in the amount of $600 that's payable to the Otsego County Clerk to be dispersed to Straits Area Narcotics. Crime victims assessment of $130. Court cost of $325 and a $68 state cost. The court is going to impose on that file a $30 per month supervision fee while you're on probation. And the court's only going to impose one supervision fee, even though there's probation in 2 different files. You do have the ability to seek an appeal of the sentence. And Mr. Cleon, if you could provide that to Mr. Shaw, and ask him to acknowledge receipt of this.
Your Honor, on the supervision, and I'm not really clear, maybe this is the way I would know. It's very likely, I mean, it's very unlikely that he's going to lose probation at Otsego County. Will that then just transfer to the county that's going to supervise him, do you know, or?
Mr. Julio, can you address that?
Yeah, it'll be transferred to this county president.
Okay, so he'll pay his fines and costs here, but for probation or supervision,
It's just paid to the Department of Corrections.
oh, okay. So it doesn't matter where.
Correct.
Okay. Yeah. Turn these copies to the judge, your copies. Go, Shaw.
Yes, thank you. And Mr. Shaw, we're very sure
Oh, he didn't sign this one.
Oh, Antoine, I'm sorry, you signed one, but you had actually 2 pieces. Judge Mertz, good to see you. Take care.
Thank you.
See you. Are you off record?
We are still on there. Okay, that concludes our morning docket before we recess.